A beautiful afternoon to you. Many thanks for joining me on the program Flipside. I'm yours sincerely, Oluije Oihohai. It's a beautiful Wednesday, yes, and I know lots of persons out there are already going about their duties one way or the other. All right, we'll meet today in the studio to discuss something very, very important. In fact, last year in the month of December, a lot of Nigerians were already telling their wives, so we are not married. We are just cohabiting. All right, with me in the studio is a person of Barrister Joseph Alegu. Good afternoon, sir.
Good afternoon.
And Happy New Year to you.
Exactly.
The last time we saw was last year.
Exactly.
Okay.
Well, we dealt on the issue of wills.
Yes.
You're welcome to 2022. All of the best of the year to viewers and everyone at home, and your offices and wherever you find yourself and you are reaching out on ITV. God bless you.
Okay, now today we'll be talking about the issue that has to do with marriage. Yes. Where the Ministry of Interior consigning registry says validity of marriage certificates. Yeah, we know last year the Ministry of Interior, ICOI, precisely said those persons that go married in that said Ministry of Interior, that their marriages were not valid. So we got to see couples coming out and just, you know, jokingly laughing about it and all of that, saying to themselves, so we are not married as far as the law is concerned. Today we have a legal practitioner with us today that will be giving us straight more insight as regards all that's conspired and happened in the month of December as far as marriage is concerned for the Ministry of Interior. But first I want to ask, what is marriage as far as the union is concerned?
All right. Marriage is very important to society, as it were, because that is where you have the formation of the building block of the society. It's from there children come from. You have, union, although, a lot of efforts are being put into making people not to be victimized on the basis of the circumstance of their birth by being referred to as legitimate or illegitimate children. But you cannot stop what goes on in the social milieu, because we don't live in isolation as human beings. We live within the context of humanity, and we interrelate and interface with other human beings, as it were. And anywhere you find yourself as a community or as a place of residence, or as a place from where you come from, as a tribe or state or nation, there are things that are obtainable. And sometimes to be a free agent and a free citizen that will move around holding your heads high, you like to comply with conventions and practices that are seen as good and standard. So marriage in relation to the act, because we're narrowing it down now, because there are other marriages such as customary marriages and Islamic marriages. So marriage after the act is a union of one man and one woman. It's a binding union recognized by the law between one man and one woman.
Okay, now talking about, you talked about, before we delve into marriage certificates and all of that, now you talked about legitimate children, illegitimate children. So we want you
from the social context.
Yes, from the social context.
The law have been able to dive in to protect, such persons. That in as much as I've come to life, I'm not responsible for the circumstance of my birth. Whatever my parents have done or the people who brought me to life has done, maybe through illicit union, as it were, or maybe through rape, or maybe through other means, and I come to life. I have come to life. I'm a responsible citizen. I should be seen so, not giving a kind of toga or tag that looks negative, with which society will see me in a bad light. So the law have been able to come up with that and to protect such persons from such. So I've been delving into that, using that term.
Right.
But within the social context, you might still be having, such, going on. So that is why marriage is one vital institution that protects such individuals from any kind of reflections that will be of such.
Okay. Now, I want to ask, when we talk about, so many persons say, I have my marriage certificate, or you go to some organization, they'll tell you, okay, where is your marriage certificate? So we want to know, what is marriage certificate?
All right. There are institutions or authorities recognized by law that is supposed to give validity or give essence to a union. So when we talk about formation, we are talking about creation or establishment or bringing to life a union. It's quite different from registration, which has to do with documentation. So formation, annulment or dissolution of marriage is governed by the Marriage Act and Matrimonial Causes Act, as it were. And this is a law of the Federation or the law of the National Assembly that has to do with Nigeria as an entity. So the laws, the Marriage Act, M6, Laws of the Federation 2004, is a law that governs everything that has to do with formation of marriage, bringing marriage to life, creation of marriage, that has to do with giving life to marriage or establishing the marital union under the eyes of the law. So if you want it to be something that the law will recognize, how should I go about it? This is what the Marriage Act is all about. So when you talk about a certificate of marriage, in section 32 of that law, the Marriage Act, it says the marriage certificate shall be the instrument or the document that is vital to show in evidence to any authority concerned of a union having come into being. So the marriage certificate is so important to a union that when you want to present it maybe before any authority or institution or any place that is concerned with evidence. Evidence means show me something that will show that this thing is in existence. Yeah. The marriage certificate comes into play in relation to the marriage after the act, or the marriage based on the act, or the marriage that comes by way of the provision of the Marriage Act. The certificate is very important in showing evidence of such marriage.
Okay. So in our society, in the scale of 1 to 100, how important is this marriage certificate? Because we get to know of some persons that they don't have marriage certificate. So are we saying they are not recognized in the society as being married?
They are, because you can contract your marriage under Islamic, or the Muslim way of life, or institution, or religion. You can contract your marriage based on that. And also traditional. There are different traditions. We have the Bini tradition, we have the Igede tradition, we have the Igbo tradition, we have the Fulani tradition, Hausas and all of that, Yorubas. So if you come within that context, you can have marriage, and there are different things that that goes with it. Like one is that you can have more than one wife. The law is not going to frown at you because you are married under a traditional setting, and whatever is acceptable within the context of that traditional setting in which you got married to, you will be allowed to practice your marriage and enjoy same. So also with Islam, I think the Muslims are allowed to marry up to 4, and while under the traditional setting, polygamy thrives, and you can marry as many numbers as you can cater for as you want to. But within the marriage, under the act, it is one man, one wife. So it is quite different. So that is why the marriage, under the act is a different ballgame altogether. And sometimes people look at it as Christian marriage, or they call it registry marriage or court marriage. But however you look at it, you want to describe it as it were, which is marriage under the act. That is the right term to use. That are married under the act.
Okay. Now, we know of some churches that when a couple, they want to get married, they'll say, okay, you go to a particular place, like a Ministry of Interior, for example, to go get your marriage certificate, and in turn, Ministry of Interior sends it down to the church. Why you find some churches, they don't even bother. You just go straight on the set day of getting married. They get the couple married and all of that. So we want to know, in between the church and Ministry of Interior or the local government, now, would you say the church that they don't give reverence or they don't approve of court marriage, will you say it's something important or something that one can go ahead with? Churches that just organize marriages without letting the couple know, hey, you need to go to the court to go get yourself legally married.
All right. You see, everything about the act is given life by the Council of Ministers.
Okay.
And it properly falls under the Ministry of Internal Affairs, now Ministry of Interior.
Yeah.
And within the Ministry of Interior, the minister can carry out, responsibilities, his responsibility all by himself or delegate. Okay. He can delegate to the permanent secretary or any other person he so chooses. Within, exercising such discretion within the confines of the permission that the law accords him. And so when the minister is carrying out his responsibility, there are also, things in the law, in the enabling act he should look at while carrying out his responsibility. One of such is that he can, do these things. For instance, the law says before you get married, there must be notices. And this notice will be issued you by the registrar. And the registrar, upon this notice, will make sure that an affidavit is passed on to the minister, who will certify that there is no impediment to your marriage and will grant a certificate. It is with that certificate you cannot contract a valid marriage, either before the registrar or before, that is a registrar, of the registry recognized by government and created by the law through the enabling law, which is the Marriage Act, or licensed place of worship in accordance with their mode of conducting marriages. Different churches have their mode of conducting marriages. And such a place must be licensed as a place where marriage can be conducted. Not just that it's a place of worship.
Okay, so sorry to cut you short. Are we invariably saying that there are some churches that are not licensed to conduct marriages?
Yes, but you wouldn't know until you make your inquiries. That is why you are supposed to ask, is this place a recognized place? Because if it is a recognized place of worship that is licensed to so conduct marriages, a book of marriage, a book for marriages that carries those certificates and all those forms, the forms of notice, the forms of certificate and licenses, where it is so granted by the minister from which you are going to detach from, will be there. Such that if they don't have such things, it means that they are not licensed, because if they are licensed, those are the instruments for work or for carrying out their responsibility that they'll be given from the ministry. So you have, for instance, okay, if there is no impediment to the marriage and you have come with your affidavit, the minister gives you a certificate with which you are going to take to the registrar or to the minister from a recognized place or licensed place of worship to give you, a valid union under their own practices. But if it is before the registrar, he also has what he's going to do within the confines of that. Because, for instance, he must pay attention to the time limit, which is between 10 o'clock and 4 within the day. And if it is a minister, there are certain things he's supposed to do too, to make sure that before the eyes of the law, everything that he's supposed to do have been done to give life to such a marriage. So it is not as if, okay, it is that of the registrar that is more valid than that of the church. That of the church is also as valid if they have the license, if they have been issued a license by the government to be a place where marriages after the act should be conducted. If they don't have such license, it means that they are out of such, a body or such a place of worship that should conduct marriage. Not that they cannot worship, but when it comes to the issue of conducting marriages after the act, they are not licensed to so do. So, but for the minister, he can delegate. He can delegate through licenses. And if whoever he delegates power to, because we have subsidiary delegation, legislation, such as directions, notices, such as orders given by the minister, by which he can delegate some of these powers, in the act to certain persons to carry out different responsibilities, such as, the acts, provision of powers, for the act. There is something there that delegates power to the permanent secretary of the Ministry of Interior to do certain things that the minister is supposed to do himself. And also delegating powers to the Ministry of the State responsible for marriages to carry them out. So if there is no notice of such, and there is no order, or there is no regulation of such to such a state or such a ministry to so carry out, they are not supposed to carry out such, an act. And also, even if they have been so delegated to carry out something, it does not foreclose the minister or the ministry from carrying out such thing. For instance, okay, I've delegated you issue of, giving out licenses or certificate. Please, you can give out licenses and certificate. I've given you books concerning such. Anybody who comes and you discover that they have met with the terms, please give them. But I can also, on my own, Because if I don't have powers, I can't delegate it to you in the first place. So for me to have delegated power to you and you are trying to shut me out is either ignorance or you don't actually, you are not actually at home with the terms of what the law requires of me. Because it is the powers that I have that I delegated to you. So on my own, I can carry out those things despite the fact that I've delegated such powers to you. This is where, sometimes even when the ministry gives notices and directions and regulations, people come back to say, now that you have given out this, you are not supposed to be in charge or to carry such a thing. And they will be quoting the law while you are quoting some of the practices that have been there for years.
Okay, now, last year, December to be precise, the order came from the federal government that Ministry of Interior, Ikoyi to be precise, the marriages that have been conducted there were illegal. They were not valid. Now we want to know, what's the court stance, what's the implication of this? What's the court stance on this issue as regards Ministry of Interior, marriages being conducted there that they are not valid?
It's all right. Decisions of the court, except it is a final court, maybe like the Supreme Court, and you have gone all the way to the highest court, you are saying, okay, it is infallible because it is final. It is not final because it is infallible. I've gone the whole road through, and this is what the court has pronounced as the law. So I'm going to come to terms with it. It happens in electoral matters, it happens in some other matters. It's like this. I think this is a court of first instance. There is a high court. They have the Court of Appeal. They have the Supreme Court, to bring this up before them so that they can look. Because when you start challenging, the decision of a court has given its decision, and once that is done, it becomes functus officio. You cannot tell a court, go back, review. It's like you're telling the court you are foolish. The court is not actually foolish.
Okay,
but
so
law,
what's the implication of the court's ruling on marriages?
Yes, what I'm saying is that the court is not a Father Christmas. You bring issues before the court to look at. You present your evidence. Your counsel represents you and, brings up your case before the judge, and he looks at this side, look at the other side, and gives his decision. If you felt maybe the judge or the court did not avail its mind to certain areas, or maybe to certain weights of arguments or evidence, you could as well. That is why there are opportunities or windows of appeal for you to bring up some of these issues. Not just, cajoling the court or abusing the court or trying to, talk ill of the court. No, that is not your place to do. They have looked at it based on what they have before them, and they have given their decision based on what they think is right. So it is your responsibility now, because equity will not lie on the side of the indolent. You must be pragmatic. If you know that you have something more to get out of it, you get up, be up and doing, approach the higher courts and, present, some of those areas or some of those grounds of appeal that you think that when the court looks at it, the judgment might turn in your favor. Okay. So to me, what the court has given as judgment, stands. And it is challenged. Maybe in the upper courts, maybe like the Court of Appeal or Supreme Court. And two, the citizens or those who are involved should be patient enough to look at the details of the judgment. Okay. Because it is not all the prayers that you bring before court that are granted. Some might be granted in whole, some might be granted in part, and some might be denied or refused totally. So the part that is granted might be jurisdictional. That means it might have to do with a local government or a state, not just the nation as it were. Yeah. So when you look at it and you know that, okay, it's covering this state, or maybe the court is saying, this is the only persons that have approached me for justice, and this is the person I am dealing with. For others, maybe you can take a look at what we have done and also approach other courts and what have you. Not for foreign shopping, but to also press home your demands for justice, because you have seen something good that came out of your brother or your sister state or sister local government council, that something good came out of it. So I should also take advantage of this to press home my demands for justice. But as to the matter of judgments of court, once they are given, the court becomes functus officio and the judgment stands or it is challenged. So when you challenge it, you are saying, I have something more I want to get out of this. And the higher courts will look at it as it were.
Okay, now, the ruling, does it stop the Ministry of Interior from conducting any marriages further?
You see, sometimes there is this, separation of power. It's to the effect that you must allow me as the executive execute. I must allow you as the legislature make laws, and you must allow me as the judiciary interpret. But most of the times, these things are not just, with tight fist or with iron cast, because you can see sometimes the executive will be presenting the executive bill to the legislature for consideration, and you might see also the judiciary trying to gauge, by public policy, watch the mood of the nation to also see how they can stabilize things through their judgments and all that. So, but once it is given, you might be accusing the executive that they are not obeying the orders of court. The executive might be saying we are within the ambit of the law because this is what is written in the law that we should operate with. I think to stop this back and forth fight, the best thing is to approach the court through the hierarchies up to the top. And I mean up to the top, up to the Supreme Court, so that matters relating to a particular subject matter which is still in debate can be settled once and for all. Okay.
All right, if you just joined us, this is Flipside, and we are looking at the court ruling as regards situation on Ikoyi Ministry of Interior, saying that the marriages being held, they are not valid yet. So what we're asking right now, could it be that the marriages over time, or if it's just the month that was being said that are not been valid? And right now, since the federal government has come out, the court's ruling has come out to say marriages being held in Ikoyi Ministry of Interior and not been valid, that these require, is it a nationwide aspect? Is it a nationwide thing, or just the Ministry of Interior as regard Ikoyi Ministry of Interior?
You see, most of these marriage registries, there's what we call registration areas. The minister is supposed to, appoint, principal registrars, deputy registrars, and to create registry zones within the country. There are those that are already captured in the act. And from time to time, he can create, and make the public or the nation aware of such. Of course, you know that once issues are published in the government gazette, it becomes authentic information. So what is supposed to be done, just like INEC is empowered by law to delineate constituencies. So also, one of the things, I'm sorry to digress a bit, with our nation is that when population is expanding and times are changing, we don't seem to catch up with judicial reforms and maybe to bring up the law to speed with some of the population expansion we're having and some of the areas that are developing. Even when it comes to maybe planning our cities and towns, you begin to see shanties and, all that all over the place, because the ministry or the government authority that it has to do with some of these things are not up and doing. We're doing what is needful at the right time to cater for the expansion. So I think, some of the things in the Marriage Act ought to be reviewed, as in, brought up to speed. Maybe discover that the population is getting wide, and how to, delegate fuller powers or more powers to the local government to handle some of those things, so that the nation can be busy with other more serious affairs. For instance, in the fourth schedule to this constitution, where it talks about the registration of marriages, births, and deaths, being given to the local government. If you look at it, it will just look at, a mere statistical function that is given to the local government. But when it comes to that of the Ministry of Interior, you look at it that when it comes to establishment, creation, bringing to life the union, it is given to the Ministry of Interior that functions through what is registries. So if a registry is created by the ministry, and the ministry is so empowered to create, registries for the purpose of conducting marriages and carrying out other functions that relate thereto, any marriage conducted by it in the eyes of the law in accordance with the act is valid. But if the court maybe didn't avail their mind to that, or maybe the other party brought up, weightier arguments, it is left for the other party to say, no, this is the law. It has not been annulled, and it is an act of the National Assembly. In fact, it is, an act of the Constitution by it is a part of the Constitution by implication. I need to take this thing up so that it can be critically looked at, because I believe that something good can still come out of this. But you cannot just go and begin to maybe bamboozle the court that has given his judgment and has washed his hand off that. Once it does that, as I said earlier, is off that. It is left for you to take it up. So when it comes to the marriages that are so conducted by recognized registry, created by the Ministry of Interior, they are valid before the eyes of the law. Because the only way that of the local councils can come in and say, okay, we can also conduct marriages, is when the powers to so do is delegated from the Ministry of Interior. That's the position of the law. I'm not a government lawyer. I'm in private practice. But what I'm saying is that from the Act and from what I've read and I've looked at critically, it is only even in subsidiary legislation where it has to do with delegation of power through notice, through direction, through other maybe like circulars or what you could call such. That is when you can say, okay, I now have power to do this because it has been delegated to me by the authority so concerned. And even at that, the authority still has powers to do what it delegated you to do.
Okay, thank you so much, Barrister, for making sure you're here today to, enlighten us more as far as the ruling, the court judgments as regards the Ministry of Interior concerning marriage certificate being invalid. We'll go for a short break, and when we'll come back, we'll talk more concerning this. Don't go nowhere. Many thanks for joining us on Flipside. With yours sincerely, Oluije Oyihoka. I still have Barrister Joseph Alego here with me in the studio. Just while the adverts were being rolled and all of that, we were talking about superiority between the local government and the Ministry of Interior. Now, I would like Barrister Alego to do justice in that.
All right. The state government is a continuum as well as an interconnectivity. In other words, there will be no federation if there are no states, and there will be no states if there are no local governments. So most of the times the tiers of government and also the arms of government work together to making sure that good governance is delivered to the people. So when you talk about superiority, there's actually no contest here, except that the matter have been brought before the court to pronounce upon. Because when it comes to the ministry saddled with the responsibility of the act and everything relating to it, under which we're talking about issuance of marriage certificates and all that relate to vital and valid unions, it is the ministry that is saddled with it. And so just as I said, the ministry having its powers can delegate same under the delegation of powers regulation. It's a subsidiary regulation. Subsidiary in the sense that the act is superior to such a regulation that is made as a direction or a notice. So if they so delegate such powers, by giving a license to a place of worship to conduct marriage, fine. If they so delegate powers to such a ministry of the state concerned with marriages, maybe the state have looked at it and have saddled, okay, maybe because the House of Assembly within the fourth schedule to this Constitution can make laws or can saddle the local government with extra responsibility beyond those ones that are captured there. Because in point I, we're talking about what? The registration of births, deaths, and marriages. And there are other things there, motor parks, abattoirs, and all that. So if the House of Assembly looks at it, that, okay, this responsibility can be saddled upon the local government, so be it, within their jurisdiction. And if the Ministry of Interior now looks at it, okay, such and such a ministry within the state, has been saddled with this responsibility, let us delegate power to them to so function. By virtue of that subsidiary legislation, which has to do with a notice or a direction or a regulation, they can act within that power. But it doesn't stop the ministry, because if you don't have powers, you will not donate. And even if you donated power, you still have powers to so carry out what you donated power for. So in the light of superiority, I don't want us to look at it from that angle. I want us to look at it from the angle of, has power been delegated to such a place to carry out, this thing?
Function.
Yes, by the Ministry of Interior. Is there any power coming from the minister or from the permanent secretary of the ministry, for such a place to carry out this function that is ordinarily theirs to carry out? If such powers are delegated, fine. And I said one of the proofs that such powers have been delegated is that the marriage book, which contains all of these forms and certificates, will be there. It will not be different from that of the Ministry of Interior. It will be the same. Because if you've been granted license, these are the things that will be given you. So that if I go to the registrar or the registry in the Ministry of Interior, the same thing you gave to me from a licensed place of worship in a church is what I will see there. Yes. And you are supposed to return back as a place of worship that is licensed to offer such licenses. You are supposed to return a copy, a duplicate copy, back to the ministry, for filing. There are books there, there are forms there where everything, all the details from E is to be given to you. From F, you register it in the place in the registry before with the ministry and all that. So if you ask me, there is no contest here. And if there is a contest that is where, it is for our leaders, those who have elected, who are in the legislature, the National Assembly, Senate, the Senate, and the House of Representatives, to come together, look at these things, and be able to do what? Come up with some work that will, lock up, close these loopholes, so that the citizens will not be posted from pillar to post, asking which one is not valid.
Because there was a time the court came out, the federal government said, okay, marriages rather being conducted in the local government and no longer valid, that everyone should go to the Ministry of Interior. Now there is a ruling that says marriages being conducted in Ikoyi Ministry of Interior, they are no longer valid. So we, like you earlier said, the torso here and there. We want to know, where should people go to? Like someone wants to, get a marriage certificate for a particular purpose. Where should one go to? Should it be the Ministry of Interior or the local government?
I will still come up this way.
Yeah.
Both. Let me clarify. By law, it is the Ministry of Interior, and the registries it has set in place for that purpose. But if certificates, licenses given from the minister is authorizing
to the local government,
yes, to so carry out that function, they can do within the context of that direction, of that notice, of that power delegated to them to carry out. But if there is no delegation of such powers, you'll be shooting yourself below the belt. That is from the position of the law. But I'm also saying that from what the courts have presented, and everybody is like, oh, does it mean all that we have done in the marriage registry at Ikoyi is wrong, or everything is? Go up. The Court of Appeal is there, the Supreme Court is there, so that these things can be given more life, and the question and all the dust it has raised in relation to this will be settled once and for all. But as far as the court is concerned, it has given its judgment, and its hands are off that, from that level. And as far as the Ministry of Interior is concerned, they are looking at what the law says, the Enabling Act, and they are functioning within that Enabling Act. Except if you will say, okay, this law is null and void to the extent of its inconsistency with the Constitution. But they will tell you that we are deriving our powers from the Constitution because the Marriage Act is part of the Constitution, and the Matrimonial Causes Action Act. We are deriving the powers from the constitutional provision. Because if it's an existing law and it has been incorporated into the Constitution, it becomes a part of the Constitution. So the best thing to do for those who are asking questions, where should I go? From my analysis, I've told you I'm not a government lawyer, I'm not a government spokesman, neither, I'm just giving analysis based on what the law says and what is obtainable. For me, if one is looking at it, okay, I want something valid in the eyes of the law, the registries, from the Ministry of Interiors under the Marriage Act, and then the places of worship so licensed by the Ministry of Interior to carry out marriages. Because from what I've read in relation to what the local government should do, it is that their function is what? Registration, of births, deaths, and marriages. And marriages, I told you that they are customary marriages.
Yeah.
They are Islamic marriages.
Sure.
And they are marriages after the act or based on the act. So, but for the Ministry of Interior, it is exclusively formation. That is item in the second schedule now, item 61. Strictly formation, annulment, and dissolution of marriages.
Okay.
Excluding, it's clearly written there, apart from customary marriages and Islamic marriages.
Okay.
Apart from, it's written there in black and white.
So, invariably, marriage being conducted under the law.
Yes, under the act.
Under the act.
Yes, because the customary law, the Islamic law is still recognized by the law,
Okay,
but
so
not
under
the
the
act.
act,
Under
okay.
the act.
Okay.
You said formation. And the last time I checked, formation has to do with establishment, creation, bringing to life, you know, the beginning of something. While registration, the last time I checked, has to do with what? Filing or bringing documents, you know, to a place, you know, registering, putting documents across. But formation has to do with what? Creation, establishment, bringing to life. So that aspect is what I'm looking at. That if they are responsible for bringing to life, then they can now talk about annulling save or dissolving save. If they don't have powers to bring to life, then what powers should they have in annulling or dissolving? So the local government has powers to register, not just marriages alone, but burials and deaths. So if I understand what the law is talking about, the function of the local government for now is statistical. You know, making sure that within your jurisdiction, all that has to do with marriages are intact, you capture them. All that has to do with burials, you capture them. Deaths, you capture them. All that have to do with beds, you capture them. So, but if by the doctrine of covering the field, the federal government is trying to impose its authority on the states and the local government, the law will say so, either excusing you or barring you from doing such. And if the states are coming maybe under a concurrent power given to them to make laws in relation to such, they should be able to point out the item in the schedule to this constitution that is saying so. But as we have it now, under the exclusive legislative list, item 61, that is where the Ministry of Interior is hooking up and deriving its powers and saying, well, anything that has to do with formation, annulment, and dissolution of marriage after the act, apart from customary and Islamic, we have powers to so do. And we have been conferred with powers under, you know, the Marriage Act, Cap M6, LFN 2004. So these are the things. So the issue of superiority, if there is any there, I want the authorities and regulatory powers concerned not to just allow the citizen be tossed about like this. If you be able to come in, look at this loophole and settle it once and for all. Bring out a publication or maybe amendment to the law that will enable the citizen know that, okay, if I'm looking for anything married, this is where I should go. And the local government should be able to come out clearly to say, well, beyond this, you know, this thing you are seeing here on the item of the first schedule to this constitution, we've been given powers. Yes, we've been given powers to so do. And then the citizens will be clear. You know, if not, by virtue of practice that have been in our system, people will be going to both local government registries and the registry of the Ministry of Interior to carry out their marriages until the dust is settled once and for all.
Okay, now, someone asked, where can one actually get, where is the license placed to get marriage certificates? Where can one actually get marriage certificates? Yes,
there is what we call notice given by the registrar of marriages from the registries. You know, it is that notice upon the expiration after the statutory notices have been given. Then by an affidavit, the minister will give you a certificate enabling you to get married, either in the registry or in a place of worship that is licensed to do so.
Okay.
And if there are impediments that maybe you are a minor and you are supposed to have parental or guardian's consent before you contract such marriage. Maybe you're up to 18, but you are still less than 21. You're supposed to have, you know, parental consent. And so if there are such, and maybe there are some other issues surrounding the union and people are challenging it, you could go to court, or maybe upon investigation it has been cleared, then the minister will give a license for that. It is with that certificate or license that you're going to contract the marriage, which is upon, you know, fulfillment when you have done the necessity. That Form E, which is a marriage certificate, which I said in section 32 is the evidence of your marriage, upon, you know, the circumstance of section 11, 12, and 13 being fulfilled, and that is done, you can now contract a valid marriage and be given that certificate, which still in form F will be entered in the books, in the registry. So you see, everything is sending you back to the registry of Ministry of Interior. So I don't see where the registry will be out of this. Even the church, the registry, still expect it to come with a duplicate upon them giving you Form E, which is a marriage certificate in the church that is licensed to do so. Not just a church, as in any church. Yes, licensed to do so. The church will be able to do. We have gone to the ministry and we have obtained license. This is the book given to us, not by the church sprinter, from the ministry, from the Ministry of Interior itself. This is what is given to us, and this is our license, and these are the books given to us. It is from that book that they will give you a marriage certificate, which will not be different from that which is obtained. And we also have other places like registration officers, maybe when it has to do with the consulate and diplomatic missions abroad. You know, such officers are by law empowered to, which is up to the rank of secretary and above, to conduct marriages. You know, so these are the same things they are going to issue to you. It's not different, based on the provision of the law. So, but to clear this, you know, this, should I use our local parlance, wahala, on our people, let the authorities concerned be able to come out clearly and to let, because, you know, when it comes to revenue, everybody wants to, you know, put out his leg. Yes. You know, like the issue of VAT, the governors wanted it to come directly to the state. The federal government said, no, let's pull it together and share later and all that. One is how to do with revenue. Everybody likes it because it will empower me to do more. So if it is about the revenues and the fees that are supposed to be paid, let them just give the citizens and the Nigerians a clarity of what to do. You know, we are hustlers, we are strong, you know, we are energetic. So we will be able to meet up. Once I know that this thing has to do with my life, I will go to any extent to pay whatever I want to get the right thing. So the authorities should be able to come out, cleared out, so that Nigerians will not be running here and there.
Okay, I know someone watching us right now, they'll be like, we want to know the functions of the marriage certificate. You can hear of some couples saying, okay, I don't want to go to marriage under the law. I just want to go for the traditional marriage and go to the church. Why you hear the wife or the woman arguing, we must go to the court to go get married. So we want to know, what is the function of the marriage certificate? How important is it?
Okay, just as I said, it's like you're saying, how important is it? Is my certificate after I've completed 4, 5, or 6 years of study at the university? This is the evidence that I went there. This is the evidence that I got it. Okay. So, on a lighter note, that is just in passing. But what I want to say is that the law says when issues having to do with argument or presentation of evidence or whatever concerning that union, Section 32, the marriage certificate comes handy. So, the marriage certificate comes handy. So, if it comes handy, it means that it is something important that you should give the importance the very significance it requires to. So when it comes to issues of you know, protection too, you know, some let me put it very raw, some are jealous. They wouldn't want, you know, somebody to come, you know, dragging my stool with me. Let me get this stool. I beg, go look for your own in our local palace. So what we are saying in essence is that for everyone that has to protect his marriage under a one wife, one man, husband arrangement, marriage after the act comes handy. Because for Islamic marriage, it gives you a leeway. The man can go for at least up to 4. For the traditional marriage, to any extent you can go, depending on your ability to carry. But when it has to do one man, one wife, I don't want interlopers, I don't want extra baggages. It is me and my wife, me and my husband. You go for that of the act. So, and when you do that, maybe it's okay, let me honor my parents and do what tradition demands by contracting the marriage aspect, paying the bride price, doing all the owambe and everything before going for that of the registry. That is church. When we say church, you must differentiate it, because you could just go to church and what you have is a blessing
Yeah, blessing of
Just
marriage.
not even blessing of marriage, a blessing.
Okay.
A blessing.
Okay.
It is when you have paid your bride price and you now go to the church. That is what is called blessing of marriage.
Marriage.
But when you have not paid your bride price and you just go to church to do any wedding or whatever, it is blessing. We just prayed for you and that's all. So, but when you have married under the traditional system, you have paid your bride price and all, and you still go to the registry or a licensed place of worship to contract marriage after the act, it is called double-decker marriage. Double-decker. In other words, you have the traditional, you've completed that, and you are doing another one again that has to do with marriage after the act. So it is double-decker. So your marriage is double-decker. Okay. But the law forbids you, after you have contracted a marriage under the act, to go for anything traditional or Islamic. If not, it will be bigamy. It is a criminal offense. You could be prosecuted for that. So, because when you are taking the oath was for one man, one wife. Okay. So if you are varying your mind, or you think that in the future I would like to go traditional or Islamic, there is no need of going up to this, because it will be criminal for you to abandon your wife, which you married under the act, for, and except there is a proper, dissolution process, maybe by seeking divorce, and the courts, now bring the marriage to a legal end. Okay.
All right, thank you so much, Barrister Joseph Alleger, for giving us an insight as far as Ikoyi issues concerning Ministry of Interior is concerned, and this verdict was given on December 14th, 2021, and we're looking forward to see what the courts will say further as regards the Ministry of Interior concerning marriage registry. All right, so I'll be seeing you again next week for another exciting time on Flipside. Do have yourself a blessed day. Bye for now.